Hello everyone. My name is Nihat. I use my middle name, and I'm going to talk about the case I took, which is SCOULAR versus DENNEY. DENNEY is a grain farmer in Holyoke, Colorado, and SCOULAR is a grain company headquartered in Omaha. DENNEY had numerous dealings with SCOULAR in the past, and he sold his grain on a spot sale basis, basically without negotiating a contract beforehand. Sometimes they would do forward contracts, where SCOULAR agreed to deliver his crop to the elevator at some later time, and a price was locked in as for the date of the date the agreement was reached. On May 30th, 2002, they discussed a forward contract for 15,000 bushels of millet, and Denny indicated a desire to sell his millet even though it had not been grown, at $5 per hundredweight of product. SCOULAR said that selling at that price was not yet available. However, 4 days later, SCOULAR sold the millet to a buyer who purchased it at a rate sufficient to meet Denny's price. SCOULAR could not reach Denny by cell phone to tell him on June 27, 2002. The general manager spoke to Denny and mailed him a written and signed purchase contract. Denny said he never signed the contract and was not selling his harvest to SCOULAR, but a grain operator in Pauley, Colorado. SCOULAR sued for breach of contract, promissory estoppel, and unjust enrichment. Denny also counterclaimed for damages arising from SCOULAR's alleged conversion of wheat that he had placed with it in open storage. The trial court determined that SCOULAR was entitled to $82,500 in damages, and Denny was entitled to $9,875 in damages. Denny appeals, and Denny believes that under UCC 4-2-205 that he should not be bound by what the trial court referred to as a firm offer because the offer had not been made in writing. Denny says that the purpose of the section is to modify the former rule, which required that firm offers be sustained by consideration in order to bind, and to require instead that they must merely be characterized as such and expressed in signed writings. However, here the trial court found that Denny had made a firm offer, as that term is employed in the grain industry. In the grain industry, the term firm offer refers to a standing offer by a producer to sell a set amount of bushels at a set price for a set delivery date. Consistent with the ordinary common law contract principles and comment 2 to 4-2-205, this type of oral offer remains open and viable until the producer revokes it. Denny also argues that his offer has been rejected or had been rejected the first time, but SCOULAR never rejected it since they only said that they could not pay for it and that he would work on it and see what he could do. When under 4-2-206 of the UCC states, unambiguously expressed the offeree's intention to engage himself, which is what SCOULAR did. Also, whether there has been acceptance is determined by an objective or reasonable person standard. We find that SCOULAR accepted Denny's offer in a telephone conversation on June 27, 2002, where the parties reached an agreement. Following the conversation, SCOULAR sent Denny a written purchase contract on the face of which stated "Thanks, Doug," which was above the signature of SCOULAR's general manager. Here we see that despite what Denny's assertion that any contract would be unenforceable because of a failure to meet the ordinary requirements, Colorado's version of the statute of frauds provision of the UCC under 4-2-201, contracts for the sale of goods at a price of $500 or more must ordinarily be in writing and signed by the party against whom enforcement of the contract is sought. However, here the trial court found that this type of contract here fell under the merchant exception, which states that within a reasonable time of making an oral contract, if a merchant sends written confirmation to another, and if the confirmation is definite enough to bind the sender herself, then the merchant who receives the confirmation will also be bound by it unless he objects in writing within 10 days. Therefore, a contract was made and the judgment is reversed and Denny's petition for a rehearing is denied, making SCOULAR the winner of the case. When it comes to the business world, the court's ruling definitely makes it so that I would have to be careful when I'm speaking to other clients that I do business with. Uh, I must know the laws in order to avoid a situation like this ever happening to me in the future, especially contract laws and general business laws. And the ruling also makes me realize that I would always need to make a contract, no matter the size of the deal or no matter how close I am with the person I'm doing the deal with, to protect myself and the company. Especially if I'm a merchant and the person I'm doing the deal with is a merchant, and if we have some history of doing business together. Yeah, and that is the end of my presentation. Thank you guys for listening. I hope you enjoyed.